Greetings. I hope that this video finds you and your family in utmost good health and in good cheer amid these trying times caused by the coronavirus pandemic. This video is created for the benefit of my second year JMC College of Law students in order to supplement the discussions on the rules and civil procedure. Now, if you are not one of my students and by happen chance you stumble onto this video, I bid you welcome. It's my sincerest hope that you would find the discussions herein informative, convenient, or at the very least, helpful. And with that, let us begin. In the immediately preceding video, we completed our discussions on petitions for relief from judgment under Rule 38. Accordingly, we shall continue our discussions in the present video on the remainder of the post-judgment remedies applicable to judgments which have already become final and executory. And these are a petition for annulment of judgment under Rule 47, a petition for certiorari under Rule 65, based on grave abuse of discretion amounting to lack or excess of jurisdiction, and a collateral attack of a palpably void judgment. Now, the discussion in this video would focus principally on the remedy of petition for annulment of judgment under Rule 47 of the Rules of Court. Now, before we commence our discussion, it must be pointed out to put your mind at ease that Rule 47 remained untouched by the revisions made by the Supreme Court on the Rules on Civil Procedure, which took effect last May 1, 2020. Alright, onto the topic. Now, how do we define a petition for annulment of judgment under Rule 47? This is answered by the Supreme Court in the landmark case of Alaban versus Court of Appeals 470 SCRA 697, where the Supreme Court defined an action for annulment of judgment as a remedy in law independent of the case where the judgment sought to be annulled was rendered. Now, what is its purpose? The purpose is to have the final and executory judgment set aside so that there will be a renewal of litigation. So, the assailed judgment is set aside and the case generally would be tried again. Now we go to the nature. What is the nature of a petition for annulment of judgment under Rule 47? In Dare Corporation versus Gokong et al., GR number 161122, September 24, 2012, the Supreme Court had the opportunity to discuss the nature of a petition for annulment of judgment. The Supreme Court held in that case that a petition for annulment of judgment is a remedy in equity and is exceptional in nature. The remedy, being exceptional in character, is not allowed to be so easily and readily abused by the parties aggrieved by the final judgment, orders, or resolutions. However, it should be emphasized that the Supreme Court rationalized in the same case that the petition for annulment of judgment is said to be exceptional in nature and a remedy in equity for the reason that it is an exception to the doctrine of immutability of judgment. You remember that doctrine, class? Now, in case you don't remember, let us review. If it can be recalled, the doctrine of immutability of judgment simply states that a judgment, once it has become final and executory, generally cannot be modified, reversed, or otherwise altered. Precisely, there must be an end to litigation. Now, going back to the remedy of a petition for annulment of judgment, this remedy clearly disregards and is an exception to the previously mentioned principle or doctrine of immutability and unalterability of judgments, as its purpose is precisely to vacate a judgment which has already become final and executory. Consequently, a petition for annulment of judgment is strictly construed against the petitioner. It is strictly construed against the petitioner and is given due course only when there is strict compliance with the requisites and grounds thereof as provided by the law and the rules. Now, the requisites and grounds shall be discussed in depth in the later part of this video. Now, Moreover, speaking of requisites, it should be emphasized that the Supreme Court held in the case of Republic versus G Holdings, GR number 141241, November 22, 2005, that the remedy of a petition for annulment of judgment may not be invoked where the party has availed himself of the remedy of new trial, appeal, petition for review, or other appropriate remedy and lost, or where he has failed to avail himself of those remedies through his own fault or negligence. Precisely, it is a condition sine qua non that one must have failed to avail of those remedies through no fault attributable to him. Otherwise, he would benefit from his own inaction or negligence. So this is clear, class, ha? It's very clear. A very important and crucial requirement for the filing of a petition for annulment of judgment is that the remedies of new trial, appeal, or petition for relief are no longer available, and that the said remedies are no longer available through no fault of the petitioner. Through no fault of the petitioner. The petitioner must not have been at fault, and he or she must not have been negligent in the failure to avail of those remedies. Let's have a short break, class. Let's have a short break. Apologies for the interruption, class. Alright, let's proceed. Let's go to jurisdiction. Now, in what court do you file a petition for annulment of judgment under Rule 47? Which court has jurisdiction to take cognizance of the petition? Now, the answer calls for a distinction. It may be filed with either the regional trial court or with the Court of Appeals. The regional trial court has jurisdiction over a petition for annulment of judgment under Rule 47 over a final judgment final order rendered by the municipal trial court. Again, the judgment or final order of the MTC, you file the petition for annulment of judgment with the RTC. Now, what is the legal basis? It's found in the rules of court, specifically Rule 47, Section 10, which expressly provides that an action to annul a judgment or final order of a municipal trial court shall be filed in the regional trial court having jurisdiction over the former. Now, that is clear, class, ha? MTC to the RTC. Now, what about the judgments or final orders rendered or issued by the regional trial court? In what court should a petition for annulment of judgment be filed? Now, it should be filed with the Court of Appeals. The legal basis providing for the jurisdiction of the Court of Appeals with respect to a petition for annulment of judgment seeking to annul or set aside judgments or final orders of the regional trial court are found in Section 9 of Batas Pambansa bilang 129 and Rule 47, Section 1. Now, Section 9 of BP 129, otherwise known as the Judiciary Reorganization Act of 1980, expressly provides that the Court of Appeals shall have exclusive original jurisdiction over actions for annulment of judgments of the regional trial courts. Likewise, Rule 47, Section 1 of the 1997 Rules of Civil Procedure states that this rule shall govern the annulment of judgment by the Court of Appeals of judgments or final orders and resolutions in civil actions of regional trial courts, for which the ordinary remedies of new trial, appeal, petition for relief, or other appropriate remedies are no longer available through no fault of the petitioner. Now, to review, judgment, final orders of the MTC, file your petition for annulment with the regional trial court. Judgments or final orders of the RTC, file your petition for annulment of judgment with the Court of Appeals. Now, let us discuss the grounds for the filing of a petition for annulment of judgment. What are the grounds for the filing of a petition for annulment of judgment? This is answered by Section 2, Rule 47 of the 1997 Rules of Civil Procedure, which provides that the annulment may be based only on the grounds of extrinsic fraud and lack of jurisdiction. However, jurisprudence has likewise added an additional ground of lack of due process. Again, class, there are 3 grounds for the filing of a petition for annulment of judgment. First is extrinsic fraud. Second, lack of jurisdiction. And as an additional ground provided by jurisprudence, lack of due process. Now we shall discuss these grounds individually and thoroughly. Now let us initially tackle the ground of extrinsic fraud. In the case of Philippine Tourism Authority versus Philippine Gulf Development and Equipment Incorporated, GR number 176628, March 19, 2012, the Honorable Supreme Court has defined extrinsic fraud as referring to any fraudulent act of the prevailing party in the litigation which is committed outside of the trial of the case, whereby the unsuccessful party has been prevented from exhibiting fully his case by fraud or deception practiced on him by his opponent. Now, a question may be posed. How do we therefore distinguish extrinsic fraud from extrinsic or collateral fraud? Now, this is answered by the Supreme Court in the case of Santos versus Santos, GR number 18761, October 8, 2014. The Supreme Court held in that case, for fraud to become a basis for annulment of judgment, it has to be extrinsic or actual. It is intrinsic when the fraudulent acts pertain to an issue involved in the original action, or where the acts constituting fraud were or could have been litigated. It is extrinsic or collateral when a litigant commits acts outside of the trial which prevents a party from having a real contest or from presenting all his case, such that there is no fair submission of the controversy. Now, in relation to our discussion on collateral or extrinsic fraud, the Supreme Court, in the case of Sibal versus Bukel et al., GR number 197825, January 11, 2016, the Supreme Court held that fraud is extrinsic when the unsuccessful party has been prevented from fully exhibiting his case by fraud or deception practiced on him by his opponent, as by keeping him away from court, a false promise of a compromise, or where the defendant never had knowledge of the suit, being kept in ignorance by the acts of the plaintiff, or where an attorney fraudulently or without authority connives at his defeat. These and similar cases which show that there has never been a real contest in the trial or hearing of the case are reasons for which a new suit may be sustained to set aside and annul the former judgment and open the case for a new and fair hearing. Let's have another break, class. Thank you. And we're back. Alright? Now, you may be wondering, isn't extrinsic fraud also a ground for a petition for relief from judgment under Rule 38? Yes, that is correct. Next query. What if a petition for relief on the ground of extrinsic fraud was available to the petitioner and the latter did not file a petition for relief through his own fault and instead filed a petition for annulment of judgment under Rule 47? What is the effect? Class, it should be underscored that extrinsic fraud shall not be a valid ground if it was availed of or could have been availed of in a motion for new trial or petition for relief. Now, with that, we proceed to the next ground, which is lack of jurisdiction. What do we mean when we refer to lack of jurisdiction in the context of a petition for annulment of judgment under Rule 47. Now, lack of jurisdiction as a ground for annulment of judgment refers either to lack of jurisdiction over the person of the defending party, emphasis on the defending party, or over the subject matter of the claim. So, duha klasa, duha. Lack of jurisdiction over the subject matter and lack of jurisdiction over the defending party. Now, in the case of spouses Eulogia et al. Versus Manzo, GR number 163602, September 7, 2011, the Supreme Court held that in a petition for annulment of judgment based on lack of jurisdiction, petitioner must show not merely an abuse of judicial discretion but an absolute lack of jurisdiction. Now, lack of jurisdiction means absence of or no jurisdiction. That is, the court should not have taken cognizance of the petition because the law does not vest it with jurisdiction over the subject matter. Now, jurisdiction over the nature of the action or subject matter is conferred by law. When the ground of the filing of a petition for annulment of judgment is lack of jurisdiction over the subject matter, again, it refers to total lack of jurisdiction. Now, accordingly, in the case of Republic versus TAFPA Incorporated, GR number 165333, February 9, 2010, should be stressed that in a petition for annulment of judgment based on lack of jurisdiction, petitioner must show not merely an abuse of judicial discretion or jurisdictional discretion, but an absolute lack of jurisdiction. To reiterate, class, total lack of jurisdiction is a ground for a petition for annulment of judgment and not grave abuse of discretion. Grave abuse of discretion amounting to lack or excess of jurisdiction, again, is not a ground for the filing of a petition for annulment of judgment under Rule 47. Now, let's go to the third and final ground. The ground given by jurisprudence. That is, lack of due process. Now, again, this ground is not provided by Rule 47, Section 2 of the Rules of Court, but rather by the Supreme Court in celebrated cases. Now, in the landmark case of Arcelona versus Court of Appeals, GR number 102900, October 2, 1997, as reiterated by Diona versus Balange Jr., GR number 173559, January 7, 2013. The Supreme Court held thus: now, while under Section 2, Rule 47 of the Rules of Court, a petition for annulment of judgment may be based only on the grounds of extrinsic fraud and lack of jurisdiction, jurisprudence recognizes lack of due process as an additional ground to annul a judgment. Precisely, in Arcelona versus Court of Appeals, the Honorable Court declared that a final and executory judgment may still be set aside if upon mere inspection thereof, its patent nullity can be shown for having been issued without jurisdiction or for lack of due process of law. Now, again, by way of review, a petition for annulment of judgment may only be filed if, first, the remedies of new trial, appeal, petition for review, petition for relief, or other appropriate remedy could no longer be availed of without the fault or negligence of the petitioner. Second, the grounds for the filing of the same petition, either extrinsic fraud, lack of jurisdiction, and or lack of due process, is or are present. Now, that should be clear, class. Now, let us proceed to the prescriptive period for filing. When should a petition for annulment of judgment be filed? This is answered by Section 3, Rule 47 of the Rules on Civil Procedure, which provides the period for filing of the action. Viz., if based on extrinsic fraud, the action must be filed within 4 years from its discovery, and if based on lack of jurisdiction, before it is barred by laches or estoppel. Now, this is plainly self-explanatory, class. If the ground relied upon is extrinsic fraud, the prescriptive period is within 4 years from discovery. And if the ground is lack of jurisdiction, either lack of jurisdiction of the subject matter or of the defending party, before it is barred by laches or estoppel. Again, by way of review, the principle of laches or stale demands ordains that a failure or neglect for an unreasonable and unexplained length of time to do that which by exercising due diligence could have or should have been done earlier. Negligence or omission to assert a right within a reasonable time warrants a presumption that the party entitled to assert it has abandoned it or declined to assert it. There is no absolute rule as to what constitutes laches or staleness of demand, class. Each case is to be determined according to its particular circumstances. Let's have another break. Alright, we're back. Apologies for the interruption, class. Now let us proceed with the formal requirements for the filing of a petition for annulment of judgment under Rule 47. Now, under Rule 47, Section 4 of the Rules of Court, the formal requisites for the filing of a petition for annulment of judgment are: first, must be verified. Second, it must allege the particularity of the facts and the law relied upon. Third, it must allege those supporting the petitioner's good and substantial cause or action or defense. As the case may be. Fourth, filed in 7 clearly legible copies. Fifth, a certified true copy of the judgment or final order shall be attached to the original complaint submitted to the court. Sixth, affidavits of witnesses or documents supporting the petition must likewise be attached. And lastly, the petition must be accompanied by a certification against forum shopping, as this is considered as an original action. Now, what are the actions that the court may take upon the filing of a petition for annulment of judgment under Rule 47? Now, again, the answer calls for a distinction, as there are 2 stages in the disposition of the petition by the court. Now, the first stage is a preliminary evaluation of the petition for prima facie merit under Section 5. The rule allows the Court of Appeals to dismiss the petition outright, as in special civil actions. Now, however, if prima facie merit is found, the petition is given due course and summons is served on the respondent. Now, the second stage is, if prima facie merit is found, petition is given due course, yes, and issuance of summons, as in ordinary civil cases, is made as provided in Section 6. It must be noted, however, that under Section 10, prima facie determination is not available in annulment of judgments or final orders of MTCs before the RTC. This means that the RTC generally cannot dismiss the petition outright upon a prima facie determination of the arguments thereof. Now, a question may be asked: what is the effect if a petition for annulment of judgment is granted? This is answered by Section 7 and 8 of Rule 47. If the grant of the petition for annulment of judgment is based on lack of jurisdiction, the same shall be set aside and considered null and void. Consequently, the aggrieved party may refile the action in the proper court. Now, take note, class, that this may involve a different court of competent jurisdiction. However, where the basis of the grant of the petition for annulment of judgment was lack of jurisdiction over the defendant, the action may be refiled in the same original court, provided that it has proper jurisdiction and venue. Now, if the ground for the grant of the petition for annulment of judgment is based on extrinsic fraud, the judgment or final order shall be set aside and considered null and void, and thereafter, on motion of the prevailing party, on justifiable grounds, he may be allowed to no longer refile the action. Instead, the trial court, which rendered the question judgment, shall be ordered to try the case anew. However, it should likewise be underscored, class, that under Section 8 of Rule 47, the prescriptive period for the refiling of the aforesaid original action shall be deemed suspended from the filing of said original action until finality of the judgment of annulment. However, the prescriptive period shall not be suspended where the extrinsic fraud is attributable to the plaintiff in the original action. Now, with that, we end this particular session. On the succeeding video, we shall continue our discussion on the remaining post-judgment remedies, specifically the petition for certiorari under Rule 65, based on grave abuse of discretion amounting to lack or excess of jurisdiction, and lastly, a collateral attack of a palpably void judgment. And thereafter, we would commence our discourse on execution. I shall endeavor to upload these videos in earnest when time and opportunity would allow. I would like to express my gratitude for your time and attention in attending the present discussion, and I hope that the matters conversed therein have been beneficial and constructive. Thank you. Thank you.